This is a true crime in real-time update. The latest on the biggest cases we're following at True Crime Today and the Hidden Killers podcast.
Could Bryan Kohberger's defense team really claim that the DNA found at the crime scene was planted? If so, how would that even work? It sounds like something ripped straight out of a crime show. Some elaborate scheme where an innocent man's DNA is carefully placed on a murder weapon, framing him for a crime he didn't commit. But in the real world, forensic science doesn't work like that. Evidence isn't just magically planted without leaving a trail. And yet, based on recent legal filings, Kohberger's defense seems to be toying with the idea that the knife sheath found at the crime scene with his DNA on the snap wasn't left by him at all. Instead, they might argue, it was placed there by someone else. If that's the road they're taking, they're in for a battle. Because this defense almost never works. It's been tried before, and unless there's hard proof that evidence was tampered with, it's usually just seen for what it is. A last-ditch attempt to create doubt where there isn't any. But before we get into why this argument fails, let's go back to where it all started. Bryan Kohberger was arrested in December 2022 for the murders of 4 University of Idaho students. The case against him isn't based on just one thing. It's a combination of forensic, digital, and circumstantial evidence. His white Hyundai Elantra was spotted circling the victim's home multiple times on the night of the murders. His phone records show he had been in the area several times before, almost like he was studying the location. A surviving roommate saw a masked man leave the house, describing someone with bushy eyebrows, an oddly specific detail considering Kohberger's distinct features. But the biggest piece of evidence? That knife sheath. A leather sheath found next to the bodies carrying a single source of male DNA. And after extensive forensic testing, that DNA was matched, first through genealogical research, then confirmed with a direct sample taken from Kohberger himself. This is the kind of evidence that should make a defense attorney's job really difficult. A key piece of forensic proof, found right at the crime scene, linked directly to their client. There's no real way to explain that away, unless you argue that it was planted. So let's talk about that. Could DNA be planted? Sure, in theory. If someone were determined enough, they could get a sample of someone's DNA off a drinking glass, a piece of hair, a used napkin, and transfer it to a crime scene. But doing that in a way that actually fools forensic testing? That's where things get tricky. DNA isn't just a drop of spit that can be smeared onto an object. It exists in different forms: touch DNA, blood, skin cells, hair. And forensic labs don't just test if DNA is present. They analyze how it was deposited. They look at degradation, environmental exposure, whether the sample appears naturally transferred or manipulated. They check for secondary transfer, meaning whether DNA was moved from one object to another rather than directly placed there. If someone had grabbed a used tissue from Kohberger's trash and rubbed it onto the sheath, forensic scientists would likely be able to tell the difference between that and a genuine touched DNA deposit. That's because planted DNA doesn't behave the same way. It doesn't soak into the fibers naturally. It doesn't follow the same degradation pattern as evidence that's been sitting in place for hours. And, most importantly, it usually lacks the microscopic details of how it got there. And then there's the chain of custody. When a crime scene is processed, every single piece of evidence is documented, bagged, sealed, and tracked from the moment it's collected to the moment it's tested in a lab. There are logs detailing who handled it, when it was moved, how it was stored. If DNA had been planted after the fact, there would need to be a clear breach in that process, something that would stand out in an investigation. And let's be honest, this was one of the most high-profile crime scenes in the country. It wasn't some backroom investigation with sloppy procedures. Every step of the forensic process was being watched, scrutinized, double-checked. And in all of that, there has been zero indication that any contamination or mishandling occurred. So, if the defense really wants to go down this road, they have a huge burden of proof. It's not enough to just say the DNA was planted. They need to show who planted it, how they planted it, and why. And that's where this argument usually falls apart, because if Kohberger didn't leave that DNA behind, then who did? Who was at the crime scene? Who had access to his DNA? Who had a motive to frame him? If you're going to argue that evidence was staged, you can't just throw out the possibility. You need to give a jury an actual alternative suspect, someone real. And so far, the defense hasn't provided one. Instead, they seem to be relying on broad claims about forensic labs being unreliable. One of their key strategies in pre-trial hearings has been to question the use of genetic genealogy, arguing that the FBI's methods of tracking Kohberger's DNA through his relatives were flawed. They've also hinted at the idea that forensic evidence is never 100% foolproof, planting seeds of doubt in the jury's mind. But questioning the reliability of forensic science isn't the same as proving DNA was planted. And unless they have actual evidence that it was tampered with, this argument is unlikely to go anywhere. The bigger issue for the defense is that this isn't the first time we've seen this strategy used. It's been tried before by people who were clearly guilty, caught red-handed, who had no other way to explain the damning evidence against them. And history tells us exactly how this tends to play out. Because when a defense team starts claiming someone else planted the evidence, it usually means they don't have a better explanation. And in most cases, juries see right through it. This isn't a new idea. Many defendants have claimed that evidence was planted by a real killer. But when the case goes to trial, the strategy almost always falls apart. It's one of the oldest tricks in the book. When the evidence is overwhelming, when the forensic results can't be explained away, when there's no plausible alibi, some defendants throw up their hands and say, "I was framed." And not just framed in the vague, "the cops are out to get me" way, but in a much more elaborate sense, that the actual killer carefully staged the crime scene, placed damning evidence exactly where investigators would find it, and then disappeared without a trace. The problem with this kind of defense is simple. To pull off framing someone, a real killer would have to be unbelievably meticulous, collecting the right DNA, knowing exactly how law enforcement processes evidence, and making sure they themselves leave behind absolutely nothing. No stray hairs, no fingerprints, no fibers from their clothing, no surveillance footage catching them nearby, no suspicious behavior before or after the crime. In reality, that kind of perfect crime doesn't exist. Forensic science doesn't let it. And that's exactly why, time and time again, this defense collapses in court. Because when you step back and look at these cases, there's a common theme. The "I was framed" argument only comes out when there's no other way to explain the evidence. And that in itself is a red flag. Cristhian Bahena Rivera tried it, Diane Downs tried it, Henry Segura tried it, and they all ended up exactly where they belonged. Let's start with Rivera. In 2018, Molly Tibbetts, a 20-year-old college student from Iowa, went out for an evening jog and never came home. For weeks, the case was a mystery. There were no obvious suspects, no major leads, no sign of her body. But then investigators got a break. A security camera caught a black Chevy Malibu circling the area where Molly had been running, multiple times. That car? It belonged to Cristhian Bahena Rivera, a local farm worker. When police brought him in for questioning, he gave them a story that was damning enough on its own. He admitted to following Molly in his car. He admitted to getting out and running alongside her. He admitted that she told him to leave her alone. Then he claimed he blacked out. The next thing he knew, according to him, he was driving around with Molly's dead body in his trunk. That's already suspicious. People don't just black out and wake up in the middle of a murder. But then, when Rivera led investigators to the cornfield where he had dumped Molly's body, that was the moment any reasonable doubt vanished. And if that wasn't enough, the forensics sealed it. Blood found inside Rivera's trunk was a DNA match to Molly. His car was on video, circling her jogging route. He admitted to being with her that night, and he was the one who knew exactly where her body was. With all of that stacked against him, the defense needed something, anything, to try and break the case apart. So when the trial started in 2021, Rivera suddenly had a brand new version of events. According to him, he was forced at gunpoint by two masked men he had never seen before, who spoke both Spanish and English, to drive around and help them abduct Molly. He claimed they were the ones who killed her, stuffed her body in his trunk, and threatened to kill his family if he ever spoke up. It was an absurd story. And not just because it directly contradicted everything he had told police before, but because there was not a shred of evidence that these mystery men existed. No one had seen them. No one had heard them. No DNA, no fingerprints, No tire tracks from a second vehicle. No security footage. Nothing. A jury saw through it immediately. Rivera was convicted of first-degree murder and sentenced to life in prison. Now, that's a pretty textbook case of a guilty person scrambling for an excuse. But Diane Downs, she took it to a whole different level. In 1983, Downs showed up at a hospital in Springfield, Oregon, with her 3 children in the backseat of her car. 1 dead, 2 barely clinging to life. She had been shot in the arm. And as doctors rushed to save her surviving kids, Downs calmly told police that they had all been attacked by a mysterious, bushy-haired stranger. The man, she claimed, had flagged her down on a rural road, demanded her car, and when she refused, he opened fire on her children. She fought him off, she said, and he shot her in the arm before she managed to escape and drive to the hospital. The problem? The evidence told a completely different story. For starters, Downs was weirdly calm for someone who had just watched her children be gunned down. She wasn't hysterical. She wasn't panicked. She was chillingly composed, and even seemed more concerned about herself than the kids still fighting for their lives. Then there was the crime scene. The blood spatter in the car didn't match her story. The gunshot angles didn't match either. No one else's fingerprints or DNA were found in the vehicle. And there was no sign of a struggle where she claimed to have fought off her attacker. But the final nail in her coffin? Her surviving daughter, Christy. After extensive medical treatment, Christy was able to talk. And what she told investigators shattered Downs' entire story. Her mother had been the shooter. There was no bushy-haired stranger, no carjacking gone wrong. Diane Downs had pulled the trigger on her own children. Why? Because she had been having an affair with a man who didn't want kids. And instead of dealing with that like a normal person, she decided to get rid of them. The jury didn't buy her story for a second. She was convicted and sentenced to life in prison. Then there's Henry Segura. In 2010, Segura's girlfriend Brandy Peters and her 3 children were found murdered in their Tallahassee home. It was a brutal scene. Brandy had been shot multiple times, and the children had either been drowned or beaten to death. From the beginning, police focused on Segura. He owed Brandy over $20,000 in unpaid child support, and investigators believed that rather than face legal consequences, he murdered her and the kids to make the problem go away. The case against him was strong. His DNA was found in the house. His alibi was shaky. And a jailhouse informant claimed Segura had confessed to the killings while behind bars. But in court, Segura didn't just claim innocence, he blamed a cartel. According to him, Brandy had been executed by drug assassins because she was involved in cocaine trafficking and had stolen money from the wrong people. His proof? A prison informant named James Carlos Santos, who claimed he had ordered the hit on Brandy. The only problem? Santos was a habitual liar with diagnosed schizophrenia, who had falsely claimed responsibility for multiple murders before. The jury didn't believe a word of it. Segura was convicted and sentenced to life. What do all of these cases have in common? The same pattern, over and over again. A mountain of evidence points to the defendant. They have no real alibi, they can't explain away the forensic proof, and so, at the last minute, they pull out the "I was framed" card, hoping that maybe, just maybe, a jury will latch onto doubt. But here's the thing about doubt. It has to be reasonable. And when the evidence is airtight, and the alternative explanation is nothing more than a desperate story with no real proof, juries don't fall for it. That's why, historically, this defense fails almost every time. Because forensic science makes it nearly impossible to fake or plant evidence without leaving behind red flags. If this defense has failed so many times, why do guilty defendants keep trying it? And what does the law say about it? There's something almost predictable about the way a defense crumbles when the evidence is overwhelming. You can see it coming. First, there's denial. Then, there's some attempt at an alternate explanation, something, anything, that makes the story a little less damning. And when all else fails, some defendants go for the Hail Mary. I was framed. The evidence? Planted. The DNA? Staged. The real killer is still out there. It almost never works. But that doesn't stop people from trying, because at its core, this strategy isn't just a legal argument. It's a psychological survival instinct. For many criminals, accepting responsibility is simply not an option. Not because they don't know they're guilty, but because their entire sense of self won't allow it. Some killers don't just lie to others, they lie to themselves. Forensic psychologists have studied this exact behavior in criminal defendants. When faced with undeniable evidence, people react in different ways. Some break down and confess, some retreat into silence, and some build elaborate, alternate realities where they are the victims. The ones who go down swinging with the "I was framed" defense tend to fall into a specific category: narcissists, pathological liars, or people so desperate to avoid consequences that they convince themselves of their own fiction. Diane Downs was a perfect example of this. Even after her daughter testified in court that she was the shooter, even after the forensic evidence made it clear that no bushy-haired stranger had ever existed, Downs never stopped insisting she was innocent. She gave interview after interview, each time shifting her story slightly, as if she believed that if she just tweaked the details enough times, someone would believe her. Experts say this kind of behavior isn't uncommon. Some criminals, especially those with narcissistic traits, genuinely believe they are smarter than the system, that if they just say something enough times, with enough confidence, it will become true. Others know they're lying, but don't care. They're playing to one person on the jury who might hesitate, who might second guess, who might say, well, maybe. But legally, that's not how it works. Because while the possibility of a frame-up is always there, yes, wrongful convictions happen, yes, forensic mistakes have been made, courts require evidence. And that's where this defense always runs into a brick wall. The law is built on a concept called third-party guilt. It's one of the biggest barriers for defendants trying to claim someone else committed the crime. You can't just walk into a courtroom, point to an empty chair, and say, the real killer sat there. The legal standard requires that if you want to introduce an alternate suspect or claim evidence was planted, you need more than just a story. You need actual proof. That proof can come in many forms. Maybe there's surveillance footage showing another person near the scene of the crime. Maybe there's a confession. Maybe there's forensic evidence pointing in a different direction. But what you can't do is throw out baseless speculation. If the defense argues that evidence was planted, they have to answer who planted it, how they planted it, and why. Without that, the claim is meaningless. And then there's the chain of custody. Every single piece of forensic evidence has a paper trail. From the moment it's collected, it's tracked. Where it was found, who bagged it, who transported it, who tested it. If there was any sign of contamination or tampering, it would be documented. That's why forensic misconduct cases are so rare, because in modern labs, tampering is almost impossible without leaving a trace. But the real problem with the planted evidence defense, it usually backfires. Juries aren't stupid. When a defendant makes a claim that's outlandish or unsupported, it doesn't just fail, it actually makes them look more guilty. Prosecutors know this. That's why they don't just prove their case, they poke holes in the defense's story until it falls apart completely. Take Cristhian Bahena Rivera. The moment he told the jury that 2 masked men had forced him to kill Molly Tibbetts, his credibility evaporated. The prosecution didn't have to do much, just let his ridiculous story unravel under its own weight. If his version were true, where were the masked men? Where was their DNA? Where was their motive? The second he started pointing to invisible figures, the jury saw right through him. And that's what happens nearly every time this strategy is used. The moment a defendant starts talking about cartels that don't exist, attackers who left no trace, or forensic conspiracies with no supporting evidence, they lose whatever thin chance they had of creating doubt. Now, to be fair, there have been cases where evidence was actually planted. But those cases look very different from the ones we've been talking about. Forensic misconduct has happened before, but it usually involves corrupt cops or mishandled evidence, not some intricate plot to frame an innocent person. In cases where wrongful convictions have been overturned, it's usually because new DNA testing actually pointed to someone else. Take Stephen Avery. His wrongful conviction for sexual assault in 1985 was overturned because DNA testing proved another man had committed the crime. That's real forensic evidence pointing to another suspect, not just a baseless claim that evidence was planted. Or look at cases where lab technicians have falsified test results. There have been rare instances where corrupt forensic analysts have fabricated results to get convictions. But those cases fell apart because there was tangible proof of misconduct. The difference between those cases and people like Kohberger or Downs? The ones who were actually exonerated had physical evidence supporting their claim, not just a story they made up when everything else failed. And that's why, when you look at Kohberger's case, this defense doesn't seem likely to go anywhere. If his attorneys want to argue that his DNA was planted, they need something solid. They need actual evidence of contamination. A forensic report showing an error, a chain of custody failure, a whistleblower, anything. But if they don't have that, if all they're doing is suggesting that planting is a possibility with no proof to back it up, it's going to fall apart, just like it has in every other case where a guilty person tried this strategy. Juries need reasonable doubt to acquit someone. Not just doubt, reasonable doubt. And unless the defense can give them a concrete reason to question the DNA evidence, the prosecution's case remains rock solid because history has shown us exactly what happens when guilty people claim they were framed, and it almost never ends well for them.
Want more on this case and others? Then press subscribe now and don't miss a moment of true crime coverage from Tony Bruschi and the Hidden Killers podcast.